So, dear ladies and gentlemen, it is a great honor and pleasure to welcome in this context of the ELPIS US Transatlantic Online Legal Lectures, Professor Pedro-José Bueso Guillén from our dear ELPIS partner of the University of Zaragoza, who will be talking about a topic very much up to date, matters of digitalization, and of course, the recent developments in EU competition law. Dear ladies and gentlemen, with no further ado, in order to be able to follow this precious lecture, I'd like to present Professor Bueso Guillén to you. Enjoy.
Thank you very much, Dimitrios. Good morning, afternoon, evening, even night to everybody. I will try to deliver a presentation for about 40-45 minutes, right? As I told before, I have told Dimitrios before, I really appreciate if you want to interrupt me, but this is not unpolite, and just ask a question or make a comment or make a suggestion about what I'm saying, because it is a topic where I'm working now again, because I've been working in this topic since probably my PhD, right? Because I wrote my PhD on vertical agreements at the 90s. So it is a topic which is recurrent in my literature, right? Now I am working, actually I'm trying to get some thoughts about the enforcement of the DMA, right? Which is, I think, very critical issue, very complicated system and something very new. So I will try to get some light on that for me, at least. I don't know, for everybody, maybe interesting, but I think it's something which is more, it's far away from the different prohibitions and obligations which are established in the regulation. The way they are going to implement and enforce the regulation is something which is really new. Okay, so I think we have to focus on that too. But I will try to come to this at the end of the presentation. I will just follow a little bit evolutionary approach, talking about things that I really have been working on that. It means, well, focusing on, I will try to do some approach on the topic, right, to focus the presentation, and then talking about, as EU antitrust law, we are focusing on vertical agreements and how it has been this topic evolved and changed from the last block exemption regulation to the new block exemption regulation and the new guidance on vertical restraints, right? So we'll try to get some lights here, because, but I must say, I've gone, it's just a preliminary approach, right? Because I haven't time enough to read it deeply and to think about the changes, but just to put on the table some thoughts, right? And then following the questions, probably I will raise when considering the verba and the guidance, paying attention on other pieces of law which have been produced in the last 4 or 5 years, right? Very quickly, and dealing with topics which really are connected. This is something which is really to be discussed. You know, what kind of label we can give to this piece of law, right? If we want to say it's competition law or what it is, right? Or many things at the same time, right? Trying to deal with the issues raised by digitalization in a different manner, right? Because of different issues and problems that mainly the European Commission has to face, and the tools they do have, they were unsatisfactory, right? So they deal with the issue. So, and I would focus first with the first, for me, the first regulation was dealing with this approach, which is the geo-blocking regulation of 2080, right? And try to say some things about the DMA, which has been recently passed, right? So it's a very long document. We have to read it carefully. It entered into force a week ago, at the 1st of November. It's going to be applied next year, right, in May. So, and the implementation phase is going to be critical, I think. And we will see the results actually at the end of 2023 or 2024, right? So it's not immediately available as we are going to see that, right? So I will try to deliver some final remarks dealing with these issues. The approach. Well, I think if you take a view, if you are some people who's working in economic law, right? Then you will see, I think for me are these two vectors, three vectors if you want, right? Which are moving the things forward, which are really transversal, right, in economic law and vectors of change. So they are pushing things forward, right? Because there is a need, right, to face the issues these vectors are rising up, right? The first one we're going to deal with is digitalization, right? And the second one is obviously climate change, right? We all know about ESG, about all the ODS or the DSO, right? And this has an impact, obviously, in economic law, not only competition law, but also in company law, and et cetera, right? Well, this is a vector we're not going to deal with. And the impact in competition law, we can probably see it in more in stated regulation than somewhere else, right? But anyhow, and the fact is that both vectors have can be combined with a third vector, which is common to both, which is globalization, right? So these phenomena have a global impact at the present time, or have a global fora, and the issue is that the European Union tried the rules here, right? But the problem is the geographical scope of the jurisdiction of the European Union itself, right? So, and this is one of the issues that we can already raise here, which is the so-called Brussels effect, right? Brussels effect, which, for example, can be seen if you have this approach focusing on globalization, what they're doing now, right? The Brussels authorities or Commission or European Commission, the European Parliament, the Council of Ministers of the European Union, right? There are a lot of legislative initiatives at the moment running, right? Very quickly, focusing on digitalization in different sectors. If we can see, for example, this line is more or less competition e-commerce, right? But there are many other things which are very important. And the fact is that, as we know, the European Union is not the leader from the economic point of view in many of these fields, right? If we focus on online platforms, which I'm going to do later, the issue is that there is no big European online platform gatekeeper, right, at the present time, right, or nearly no one. But anyhow, we want to establish some standards, right? We think that are accurate, right? And of course, the European Union wants to be leader in that. Also wants to lead and set legal standards in order to fulfill social and economic goals, right? According to our values. And this is something which is positive. And we are also the first one that are doing that, really from a governmental point of view. And this is also positive. But the problem of the Brussels effect is that we probably can isolate the European market from the global market if we are very strict. So this is something which is always a balance issue, where how far we can go, and to what extent it is positive, what extent is not so positive, the effects that we are trying to achieve, right? Well, this is something that I put on the table, right? It was going to flow in the presentation somehow, right? And this is something we should consider maybe at the end of the debate or whatever, right? But so to say, from a legislative policy point of view, right? This is something which is really new. Okay, and we are legislating in a field where we are not leaders from an economic point of view, trying to impose higher standards of behavior to the operators, right? And we'll see how does it run, because maybe if you're facing weaker operators, this is something which is going to run because they have no other choice. But if you are facing gatekeepers like Apple or Amazon or Microsoft, it's not so easy, I think. And this is because the DMA is so fascinating, right? This period of implementation is going to be a fight, I assume a fight, and the resistance by the gatekeepers is going to be 120%, right? So I don't know. I am going to attend a congress at the end of November in Malaga, talking about DMA, and it's going to be someone of the European Commission. I hope they are giving some clues how they are going to proceed, right? Because I'm very curious about that, right? Why? Okay, let's go on. This is my focus. I will try to keep to cover these issues, right, as examples, right, of the impact of digitalization in competition law, right? And saying a way that I think that the regulation of online platforms, it is not clear, even in the case of the DMA, if we can talk about antitrust law, or just only antitrust law, right? Because I introduced already this topic, if I not have time. If you have a look at the areas of the regulation of the DMA, the goal is to achieve disputable and equitable, right, digital markets where gatekeepers are working. What is disputable, right? This is something which is really linked to antitrust, okay? But equitable. I think the connection is clear here to other directions. For example, fair competition regulation, right? Un lauteres de PPA, right? So some of the prohibitions and obligations contained in the DMA, probably they are also entering into intersection with national regulation on fair competition. Fair trade competition, right? Fair trade. And there's something which is challenge because I'm working in the issue of private application of the DMA, if this is possible, if it makes sense, right? Because there is no special provision in the DMA about that. Different to the DSA, right? DSA already thinks about that, right? But DMA is not something which is trying. I think the Commission wants to keep so many people as possible away, right? Even if they can, they shouldn't, right? This is my feeling, right? And there is no provision about private application, private enforcement, right, of the DMA, right, by means of claim of damages or whatever, and before national courts, right? Even the competence, the jurisdiction of the European Court tries to be reduced, right, to the judicial control of the decisions applying for fines, right? But probably already know that the DMA follows a legislative approach, which is a delegation, right, on behalf of the Commission in order to develop the regulation. My opinion, the decisions of the Commission developing the regulation are also submitted to the judicial control of the European Court of Justice, even if there is a regulation done by the European Parliament and the Council of Ministers, right? But if you read, there is an article in the regulation which is only talking about the control of the decisions where the Commission is holding a fine, right? And they can void it, they can modify it, but not the ones, which is very curious. Well, okay, let's go. This is an overview of the evolution of the rules on vertical agreements, right? And as you see, the last regulation is recent, 10th May 22, entered in force the 1st of June, right? Right. And we have a long history of regulations on vertical agreements. As you probably know, well, this is something which probably I know it because I'm very old and working in this topic since many years. So if you are young researchers, this is something really you have to consider to have an insight on the history of the evolution of the treatment of vertical agreements from the perspective of competition, European competition law, right? But at the very beginning, we do have these regulations of the 80s, right, which were very different conceptually and technically from the regulation we do have today, right? Were very formalistic. They have this straitjacket effect, this all or nothing principle. And so very, very, very difficult to apply, very inconvenient for the economy. So this has to change. And the big bang of this change was in the end of the 90s, beginning of the 2000s, right? And then we have this first regulation, the 1991, the 790/1991, which was the change of the approach to a more economic, open approach, only a regulation for all vertical agreements. And this is the path has been followed in 2010 and in 2022, right? The main change from 1991 to 2010 was that the regulation, but not the regulation, the guidance on vertical restraints, they start to consider the distribution over the internet. This was one of the issues that make it a difference. And but it was, as I will show you, a very, very peculiar approach, a very narrow approach to the distribution over the internet, right? And 12 years later, and 12 years in this field are like 200 years in other fields, right? Because this is one of the issues that we have to face, that the evolution is a very, very speedy revolution, right? Very quick, and patterns and paradigms change quickly, right? Then start to consider a different paradigm of distribution of data. I will try to explain, right? But it is something which has some, this time, yes, some reflect on regulation, but mainly, and this is the issue, the criteria and the ideas, the big ideas are in the guidelines, right? So if you want to apply properly the regulation, you have to follow the guidelines, right? And this is something that is also important from a software law perspective, that we have here a very important soft law, right? Which is even more relevant than the regulation itself for applications proposals, right? And the issue is that I will show you, it will be possible to update the guidance and not to update in the regulation. And this is easier because it's something which is done by the Commission itself, right? But they don't have to do it. They only update the guidance when they update the regulation, which is something which is, I don't see why, if there are so many changes in 12 years, as they have been, right? So this is something which is can be critically regarded. And this is also linked to a problem of transparency in the application of the European antitrust law, right? Because as you know, you can see, right, the evolution of the cases, decisions of the commissions, cases in the court, they are becoming less and less and less, right? So we don't get information about how the commission is applying the law, because they are always negotiating with the lawyers of the big companies, right? They're reaching agreements. So this is something which is in a context of secrecy, right? Which is not so much transparent. So we should get an earlier feedback of the commission on what she is doing, right? When applying antitrust law. Well, this is an issue, right? Okay, come on. Well, for everybody, if you don't remember or you are not very familiar with the topic, what's a legal agreement? An agreement or consent practice entered into between two or more undertakings, each for which operators for the purpose of the agreement or consent practice at a different level of the production or distribution chain. So we have a vertical relationship. This is vertical agreement. Production, wholesale, distributor, vale? The seller, dealer, whatever you want to call it. A different distribution chain and relating to the conditions under which the parties might purchase, sell, or resell the goods. It is not just a sale of goods contract, because they are integrating, right, the economic behavior with the means of the contract, deciding, for example, pre-sale services, after-sale services, what kind of investment are going to do, how are going to be the stocks, and whatever, right? So it's not a pure sale of goods contract. An exchange contract is more complicated than that, right? But from a contract law perspective, is I would call a collaboration contract, maybe a mixture of collaboration and exchange. And we in Spain, we do actually consider that these contracts are a category in itself, right? Inside of collaboration contracts, together with agency, commercial agency, and these distribution agreements, right? Well, okay. And which are the types, but these are in case of Spain, not contractual types, but competition types of vertical agreements or distribution contracts. Exclusive supply, we will see exclusive distribution, so when you are allowed to sell in exclusivity, and selective distribution, we will see not the concept and franchising. More or less, this is the scope, right? And you can add your agency you want, because if there is not a genuine agent, it's submitted also to the rules of the European competition law in vertical agreements, right? Right. Okay, but this is something which in Spain is discussed. If agency is not a distribution contract, whatever, right? I include it, but also say no, it's something different. Okay, well. here the definitions of what is selective and exclusive distribution system. As you see, selective means that there are some criteria, specific set to be admitted in the network, right, as an authorized distributor, reseller, right? And everybody who fulfills should enter into, right? In opposite to the exclusive distribution system, what means that the supplier is selecting, right, from a very quantitative perspective, not qualitative, as should be in selective distribution, a number of distributors. Then the new issue here is that the Commission says, well, it can be a maximum of 5 buyers, 5 distributors in a territory, right? So it's not, it doesn't have to be only one. There's something which is clarifying the concept of exclusive distribution now in the new regulation, right? Okay, so we can still have exclusive distribution system, even if in a territory we have until to 5 distributors, right? Well, okay, this is something which is new. I want to point it. Because the issues we're considering distributing on internet are in passive sales, active sales and passive sales, right? This is where the impact is focusing, right? Well, I hope you are familiar with interbank competition issues, right? And this has been translated, okay? And then we can say in exclusive prohibition, in exclusive distribution, sorry, there is possible to prohibit active sales, right? We will see what is the concept now, right? And in selective distribution, it is not possible to prohibit neither active nor passive sales, right? To final clients. We're talking about to final clients, right? Right. Here, definitions of active sales and passive sales, right? Which has been changed from the drafting they do have before, right? So they are going to be one of the goals the Commission has followed in this revision of the broker central regulation and the guidelines is trying to clarify concepts, right? Because they were not so clear in both texts, right? So we do have here a new definition of active sales, right? Actively targeting customer visit, email, means of the communication, or through targeted advertising promotion, or online, right? And this is one of the issues that this new regulation is bringing with, that there is no any more difference between online and offline markets, because at the beginning of the distribution of internet there was a discussion, well, the internet market is a different market of the offline market. No, this has been already clarified, and there's no difference. There's a market, maybe offline, online, right? And price comparison services, advertising, vale. Rules operating website with top level domains, particulars, or offering. These are active sales. This definition has been, of course, if you compare with the definition before in the guidelines, updated, considering mainly the impact of the online platforms in the economy, in distribution economy, right? Okay, right. The same for passive sales, right? The same for passive sales, okay? Without sale having with immediate actively targeting the particular customer, but you have to, of course, to refer to the active sales definition, right? Okay, right. Very quickly, the ideas in 2010 were first, internet selling is passive sale, right? So you cannot forbid a buyer, reseller, right? In both an exclusive or selective distribution system, you cannot prohibit that they sell over the internet. You cannot reserve for yourself as supplier this channel. Internet cannot be only captured by right, the producer or the supplier, right? And this is something which has been clarified in a very important case, which was Pierre Fabre, right, 2011, by the European Court of Justice. Okay, but this has been already said by the Commission before in 2010, as you see, right? Okay, and this links to one of the issues I've pointed before. The regulation and the guidelines, in fact, because the regulation were not changed in 2010 from 2099, right? Only very little things, vale? But here not. The regulation in the guidelines are taking into consideration the paradigm of the brick and mortar and click shop, right? So pure players were not regarded here. Pure players as online platforms, right? So this is something. The problematic of this new that time new operators were not considered at all, right? Right. So if you have a look at this, it is passive sale on the internet, advertises of general advertising promotion of products, automatic electronic commerce, right? In distribution, inside distribution was clarified that the location clause was not violated by the distributor if he or she distributes over the internet. And this is also very important, right? Again, preferable. Right. Okay. So then there was a list of things that they were not exempted, right? So if you, as a producer, introduce these obligations or prohibitions in the contract, then you are having a hardcore restraint and not being covered by the umbrella of the regulation, right? For example, obligation of redirection customers, right? Here. But this is something, of course, that the Commission says, well, great, we have this rule, right? But the problem is, and we see later if we do have time with more detail, that many of these, the decision of redirection of customers are taken unilaterally by the platforms, by the sellers who are providing the services over the internet. So there is actually no agreement or no clause in the agreement on that. So we cannot face this issue by means of Article 101 of the treaty, because there is no bilaterally at all. And because of this is one of the reasons why we have this the geo-blocking regulation, right? Okay, we'll see later. Okay. You cannot establish a restriction of total sales. You can fix a fixed amount, but not a percentage, right? Price discrimination at that time was very bad seen, right? Okay. Okay, something which is very, you have to justify very well, only case-by-case approach, etc. Exempted if the use of internet can be regarded as active sale, for example, outlines specific to set a customer, authorized electronic commercial communication, territory-based banners, using search engines, that you are active being selling over the internet in the territory, right? And very interesting, because this connects to another issue, which is COTI, right? You know, this is a very important, also very important decision of the European Court of Justice regarding especially selective distribution, right? Can you ask for minimum quality standards in the internet platform or website to the dealer? And that would justify not to use internet if you are not doing it properly. Well, this was something which is say minimum quality standard, you have to can be required, right? Okay. About the use of third platforms, right? There at that time was a very discussion at 2010, right? Because the issue is there are many markets. Germany is a case where the SMEs, the dealers which are SMEs, mainly use these big online platforms to sell, even if they are authorized dealers, right? Okay, because they are too little to have the web page. And the German authority said, well, you cannot ban as a producer supplier to use these online platforms to the dealers, because if not, they are not going to be able to access to the distribution over the internet, right? But this doesn't happen in all markets in the European Union. This is a very German issue. And because of this, the case, Digitalisation, was a German case, right? Okay, wow. We will talk about, well, the issue you know already at the present time is that the court says, well, no, it's possible to ban it, right? If the brand of the online platform is a well-known brand, right? And then you can forbid it, because this might affect the luxury image of your producer market, producer brand, right? This is the conclusion of COTI, more or less, what they say. Well, they don't care about if Amazon is fine or not fine regarding the quality standards of the, if there are quality standards, right? Which was not the case in COTI. Nothing about that was said, right? So these are criteria which are drafted in the guidance in 2010 were not applied by the court. The court follow another path. We say, okay, it's a luxury mark. The issue of this, the use of these platforms, which are well-known platforms of third parties, right, by dealers, can affect the luxury image of the brand, so you can ban it. Finish. This was the thing. So they changed here, right? Of course, but also possible evaluation of different bans based on health and security, but this is more paragraph 101. When paragraph 1 of Article 101. Well, you know, we do have an issue in European antitrust law when you're regarding 101 paragraph 1 and 3, right? This is the so-called verdammte Spaltung in German, or the damn split, if you want to say it in English, of or analysis of prohibited agreements, right, or practices that we have to split in two, right? With this absolute disaster. This has an historic origin, right? In the decision of the European Court of Justice trying to flexibilize the prohibition at the very beginning before we do have the block extension regulations, right? But this has remained. And this is still there, and this is also very important now because selective distribution is going to be very important again. And many of the criteria are criteria which are solved in 101.1 and not the 101.3 when talking about selective distribution. We still have to deal with that. This is not good, right? But this is something we Europeans have to carry about it. As you see, there are many reasons which can be anchored in paragraph 1 and other reasons in paragraph 3 for the individual analysis. Right. Okay. I continue. So trying to come forward at the very in 2010 and following years, there were issues which are open there, of course. First, the impact of the internet in selective distribution, right? What's not clear, which is the rest of that. And if you have to reconsider what is need, what is proportionality, what is not discrimination, right? Coty has made here like a strict line fast. Everything remains as it is, right? In my opinion, this is false. I'm being very critical with Coty because I don't share the things of the. I'm more approach to the German position, right, of the Bundeskartellamt in this case than to the European Court of Justice, honestly, right? Because I think it makes sense, not because I like the Germans. It's not the issue, right? And the other issue was, and this the other anchor, these new forms or environments for the distribution, through players, social networks, and websites, open websites, online platforms. This was not dealt with, right? So we have already in 2010, 2011, 2012 these issues there, right, on the table. So in 2015, the Commission decides to start thinking about that, right? 2010, 5 years later, right? This was the sectoral inquiry, right? Very interesting, because later many things which were here are in the new, and many things that are here are not in the new regulation, right? So it's really curious the process. You have to follow that. And well, this is more or less the context of the digital strategy, digital single market strategy, which launched this procedure, right? Also, the geoblocking regulation was launched here, right? We will talk about later on that. And the objective of this study was, well, to see what's on, and to get information, to get the data, to talk with the operators, and to get the feeling. Right? Okay. Very interesting for me. Well, they split the analysis in good and digital content, right? Because this digital content was something which go to the Urheberrecht Richtlinie, the IPR directives, right? And we deal with, and the last one in 1977 with Article 17, right? And all this stuff, right? Okay, this is something which went apart. And now they focus on goods, right? And also including pre-players and online intermediation services, right? This was realistic. Okay, well, this is good. What they see, effects on the distribution strategies, please. Internet is good because it increases transparency and price competition. This is good. But the problem is, from the supply side, they were concerned because this issue price automatic tracking by the dealers, right? So it can affect to the price they are selling over the internet. These techniques. Well, it increased. It has an impact because the distribution is increasing. Of course, providers are selling directly to the final clients, over the internet, right? In order to achieve a higher control of the distribution, but also to get more profits, right, from the business. Also very important, as I said before, there is an expansion of the distribution system. Why? Try to protect the brand image, right? And of course, since Coty, if you don't have to justify that your brand is luxury brand, because it's easy enough to say, my brand is a luxury brand. Ah, great, fantastic. That's all. You don't have to show nothing else, right? It's a pure entrepreneurial decision. I have a luxury brand. Oh, great, pues esta. That's all. Huh? Then it's a way to try to control the distribution over the internet, establishing more and more selective distribution system, because this allows you to control the distribution over the internet by the dealers of your product in a higher way. And of course, the issue of the free reading, which is the traditional issue, right? Trying to get this level playing field, which is very difficult in this case, because the Commission has always this bicefal approach to the free reading. Yes, it is bad because for competition is bad, but it is good for the internal market. It is good. And they don't know. They are always mixing and changing. Well, more issues. Increased vertical integration, right? This happens, right? Geo-blocking, this phase, distribution of the online marketplaces, and they do have here the issues. Very important for us, as I said before, they discovered that, they are conscious of that in some national markets. But at this time was open, right? This criteria for justification, the equivalence, and so on, right, is important. And then Coty has closed the discussion, right? No more important. But at that time was an issue. Price competition tools, they see that with different ease, good but not good, but tracking is, well, and prices. Dual pricing, for example, something which has not been seen then, at the time not good, but it happened, right? Well, okay. The impact on the rules were, first, internet is not a separate market. So online and offline is the same market. This is something which is already assumed here. There were new stuff there. Online markets, right? Price competition tools. What we have to do that? How should we consider RSS maintenance and horizontal agreements somehow differently? And there is all stuff coming again. Selective distribution. How we should do that, right? Okay. Well, this is Coty. I don't want to go in deeper because I already said I have not translated it. This is in Spanish. I am very critical with Coty because I think it do it too simple, right? And it's more complicated than it is. And this is my opinion, right? Okay, but there is another issue I want to raise here, right? And I was saying the same, and I was criticized because of this. I don't think that the European competition law is, so to say, pure competition law. Never has been, right? Because first of all, the European competition policy, and the law is an expression of the policy, right, has been always an integration tool, right, for the internal market. But at the same time, and ever has been like this, we have also persecute some sectorial industrial goals using competition policy and competition law, right? And this has been always like it is. And this is also the case here. Why Coty? Why the Commission the approach? Because, well, we do have a lot of very luxury brands in Europe, right? In the French industry, in the German industry, that we have to protect. And we have to protect from the damages coming from the distribution over the internet, mainly the distribution over these big platforms, the gatekeepers. Because we don't have in Europe national champions, to say, in this field. We have national champions in luxury goods, in automobiles, in many things, right? But not online platforms. And this is an issue, which is an issue of industrial policy, which is filtering into why we say that you cannot use Amazon if you are member of a selective distribution system. That is, in my opinion, right? Well, okay. We continue. After this report, right? Then again, well, we are going to review the revision 4 years for review to revision. You have to consider the DMA, which is very much complicated than that, has been done in 1.5 years. Passing Parliament and Council of Ministers, right? Not only the Commission. This is amazing what happened with the DMA and DSA. It was a very urgent issue. Well, this was the evaluation phase, were the goals, right? To adapt the impact of digitalization in commercial distribution, to readjust safe harbor. At the very end, hasn't happened anything here, right? We still remain the 30% safe harbor. To simplify self-assessment by increasing the identity, well, I don't know if they have done it because any time is more complicated, right? The guidelines are higher and bigger, and then it is even more complicated for the bread as well. This is, I don't know if they have cheese. Well, clear and up-to-date rules. Well, at the present time, yes. In 2 years, they will not be more updated, right? This is the issue again, right? Okay. Well, and try to improve the common evaluation. This is one very big concern of the European Commission, right? And I understand it, that we have a uniform application of the rules, right? Okay, and this is something which is moving not only here but in other fields of law from directives to regulations, because they are afraid of how it's going to be implemented in the international system. But also, if you have regulation, your commission, you can give the path. And the Court of Justice is going to give the path, even if the directives, but in regulation, even more clearly. So there's very strict way to get an uniform law, even if Article 114 of the TT, I don't think is justifying anything they are doing with that, right? Okay, because it's very, very too much wide open interpreted. I think, but another issue, right? Well, they do the impact assessment for that, and then we get the new regulation. Where are the changes? As you see, dual distribution is an issue, right? That means the provider has the distribution plus the distribution channel, normally selective distribution channel, right? So the provider is distributing and selling to distributors that they are distributing. So there are horizontal concerns because both are distributors, not only vertical, right? There has to be phase, right? And then they maintain that if there are no reciprocal vertical agreement, that means that the dealer is not also producing and selling, right? They keep the 30% for the safe harbor, right? They have not changed it at the very end. But there is no possible to apply if the information exchange in the horizontal distributor level is not relevant to improve the system, just only for an anti-competitive purposes, right? As horizontal exchange of information, right? It's not covered by the umbrella. And very important, online intermediate services platforms are not to be considered as wholesalers or importers and are not covered by the regulation. So they are kept away, right? Why? I think because the Commission has no idea how to deal with that. Yeah? And they are trying to face the problem with the DMA, especially with the gatekeepers, but not all online intermediate services are gatekeepers. Only very few should be, right? We have all the tools, but why I don't know, right? Probably they want to do well. We'll have some case law that we're going to follow, or some issue that we're going to take a decision and try to face that and get more clear ideas. But at the present time, I think they are not so far. Well, very important also, so they deal with dual distribution, which was an issue, right? They give some path, but not very satisfactory at the very end, right? They deal with parity obligation, or most favored nation clauses, right? And saying, well, strict clauses are okay, but why they're not? Well, this is a compromise, right? Okay. The logic, economic logic there was maybe this, you agree, disagree, but this is the solution they take at the very end, right? So simplifying the idea. Another issue is how to deal with active sales, and then reconsider active sales, because what not clear was active, was passive, right? And they give this new definition I showed you before, right? Update to e-commerce, right? And following peer-to-peer, right? Okay. And also they improve the rules in the regulation, exclusivity, right? Because they allow share exclusivity, which was not dealt with, right, before, and the possibility for the supplier to oblige the distributor to pass on restriction of active to their customers, so they can do this contract chain, right, and impose this obligation to the customers. And the selectivity, you can enhance protection against non-authorized sellers. So in the fight among protecting the distributors, selective distribution and the free riding, selective distribution has won. Why? Because they see the Commission is aware that it's a very important tool for the European companies to get distribution in their own path. That's all, right? Okay. And also some measures trying to restrict online sales. Then with dual pricing, not anymore have restrained dual pricing, so you can have different prices if you justify it. It's not per se forbidden anymore. Equivalence principle is not anymore there, disappears. This equivalence of the quality of the winter doesn't matter anymore, right? This is Scotty, okay, what in back here, right? And provided bias is not intended to prevent bias, well, that you're trying to do something which is wrong, well, okay. And again, OES are out of the play, right? So especially hybrids, which are platforms and selling, right? Which are distributors as well. Okay, this is the idea. And then 2 remarks. I try to go very quickly to the rest of the focus. I'm not going to cover it because I don't want to bore you so much, right? First, as I said, this is a policy, which is not the super policy, right? It depends on and today is even not so important, even if the Digicom is not conscious about that, right? Well, they are conscious, right? Because they are giving place to other interests and goals in competition policy and competition law, right? So it's not so tragic. And the other issue is what we raised already. These tools we do have, right, are accurate to deal with the issues from a procedural point of view, technical point of view. Well, and there is no other way to regulate that. This was the question was raised in 2015, right? Okay, because we have to face problems that were not covered clearly by 101 or 102 CGT, right? And even if, right, we take so much time to do with that it's too late. We realize too late. And the market is already another point. And we do have again the problem, we have to face that, right? So we have a problem of speed, yeah, and we have a problem of that ex post control is not satisfactory because there is no more way to avoid the harm that's already been done, right? If there's a harm, well, this is something we have to discuss. So, and if you see in 2020, this graphic as banned by the Commission, we do have many issues dealing with ICT, with internet, and so on, which the Commission wasn't able to solve. Well, some of things are already solved, right? The Apple cases, Amazon cases, we have seen in Amazon that the existence of the evidence of abuse of dominant position has been relaxed to an extreme, which is really concerning, right? In the last Amazon Android decision, right? So the court says, well, if it is like this, it must be harmful. So there's a presumption of harm, which is not proved by the Commission, which is for me, it's a very, very tricky issue, right? Okay, because it's very difficult not to prove the harm, not to prove what I have not done. So, well, the issue is, this is the map in the European Union. As you see, there are plenty of medium, micro, small platforms, but we have these big ones, which is the gatekeepers, right? Which have only 80% number, but they have a lot of market share, they have a lot of market power, right? And how to deal with that? Well, I'm going to very fast, right? Here in 2018, we do have the regulation, right, based not in competition law, but in Article 22 of the Services Directive, right? So the issue is approached from a different point of view. Why? Because, of course, many of the decisions were unilateral decisions. So you cannot use 101 competition law, and they were taken by providers of internet services which have no dominant position at all, right? So 102 makes no sense to, right? So you cannot go to this way. You have to go the other way. They use the idea of 22 non-discrimination, right? Which was attended for private operators and not for public operators, right? And they try to control geo-blocking and geo-filtering, right? Not only, and of course, very interesting issues. For example, that the subject which is protected is not only consumers but also traders, which is another discussion here is, well, what is this? What you try to put a label? What is this, right? And it's consumer protection, but not only. In Spain has been interpreted as consumer protection issue, right? Because in Spain, you notice the regulations say, well, regarding enforcement and infringement, you have to decide how to deal with that. That's a member state, right? We don't give any path. You have to communicate what you're going to do. In Spain, has been introduced in the competition, Consumer Protection Act as a consumer protection infringement, right? And the consequence is a fine, right? And if the customer is a trader, can you apply it? Well, you interpret the regulation, yes, but the problem is the consumer protection authorities have no jurisdiction if there's no consumer involved in Spain. Well, we will see what happens if we have a case, right? Okay. I will connect. Well, we have three different justified geo-blocking, access to ONS interface, right? The access to goods and services, which can be justified, and no discrimination for reasons related to payment, right? I'm not going to deepen that. And this is the point: the connection with antitrust law, right? Article 6 says, without prejudice of regulation, we know we have to be updated, right? And Article 101, this regulation shall not affect agreements restricting sale activities or activities with the meaning of the regulation, or agreements restricting passive sale in the meaning of regulation, right? That concern transactions falling outside the scope of the prohibition laid down by Articles 3, 4, and 5. So this is the interconnection rule, right? And we have to assume that, within the minute, that concern transaction falling outside the scope. That means that if the behavior falls inside the scope, then you have to apply the geo-blocking regulation, and if not, then you are to apply the proposition regulation for the agreements, right? Okay, this is the consequence, right? But the issue is the issue for me here is first that we don't have. I'm not going to deep into here. The concept of active passive sales in the geo-blocking regulation and in the antitrust regulation we have studied is not exactly equivalent. This is one issue, and the other one is enforcement. So if the enforcement is like it is in Spain, I would prefer, if I was an undertaking violating this rule, being fined in Spain, applying the geo-blocking regulation, than being fined by the Commission, right? Because I am violating Article 101 of the TT. Much better, much cheaper, much easier. So, and I probably we will have here problems here, right? Well, trying to finish. Well, there were many concerns and so on. So for me, this is another issue that I won't put on the table, right? As you've seen before, the slides at the very beginning, there are plenty of things going on, right? They are being done by different actors. Stakeholders are involved, right? But I think nobody is thinking about doing something current. We are legislating very quickly and not coordinated in an uncoordinated way. And there are many overlaps which are not being considered. And that makes the law inconsistent. And this is an issue, right? So, and talking about this topic with a person who was in Zaragoza 2 weeks ago, talking about, again, online platforms, she said, no, we are working, the expert group is working in trying to do this tuning, this fine tuning, trying to connect properly the different nodes, because there is such a incoherent situation that is going to be problematic at the very end, right? So, well, and just only a couple of words about the DMA, right? As you see, I've said into force 1st November 1st, is going to be applicable in May of 2015. There's only some articles are in force already in order to do the preparatory work for that. And there's definition already now. So we have these big platforms, online platforms, right, which are offering these basic platform services, which are listed in the regulation. Have been included another, for example, WhatsApp services are now inside, where before outside, right? Okay, and but it's not the only regulation we have on that. We also have the regulation on online intermediation services, relation to rule the relationship between the platform and the entrepreneur, right, and the trader which is using the platform, but also protecting the consumers, right? And this has to be, of course, complemented by directives which are giving some rules on connected to that. Okay, and we also have here a gatekeepers concern, because it is like, well, you are submitted to DMA, but you are submitted to this regulation 2019-11550, right? Because you are also online platform in the sense of the regulation. And of course, we have DSA, right? Because many of the rules which are in the DSA are going to also be applied to gatekeepers, right? So we have this overlap of things, and many, and I have no time to do that. I want to do that, but I will take the obligation, the provision of the DMA, and I'm pretty sure that 20-30% of them are also included as a rule in the regulations. Or you can do, well, this is a case of this or a case of that, or lack of transparency, of self-preferencing, which is specifically related, and so on. So in order to know what to apply, and the problem is that and I'm finishing, right? That the DMA is trying to be a very exclusive club. That there is a very curious article 1.4, right, saying without prejudice of, and to understand what is meant with that. If there is a substantive overlap of the content of the rule, it's not easy for me. I mean, if you are banning conduct in two different norms, what do you want to apply? But the problem is, well, it's exactly the same that DMA will provide. But the problem is what is not said there, and they say another norm, but it means that you are imposing additional obligations to the gatekeepers can be applied, because the article says if there are additional obligations, then no. Right? Even if I think we are thinking here about national regulation directives which are introduced, or pure national regulation, right? If you see the footnote and so on. So, but I think the decide which is the applicable law here is not easy, right? And the problem is, depending on what you decide to apply, the effects are going to be different. And this is not something which is not is relevant. Thinking in this way of what I'm saying, that I'm working trying to say, well, is it possible to have private enforcement of the DMA or not, right? Well, probably directly not, but I indirectly see yes, because you can say, well, this prohibition is also a violation of regulation so and so, or of the transposition of the rules of the Directive 2005 on unfair practices with consumers, and then you can go this way to have private enforcement, right? So I think one of the issues we have to face when I finish here, right, is that we are going to have a lot of very complicated regulations and rules, and they are not coordinated at all. And we have to decide how to coordinate that in order to be something which is operative and effective to achieve the goals, which more or less are the same, but are not exactly formulated and are going. They are persecuted by different ways, which might interfere and make it difficult to enforce. Right. Well, I am going to finish now. I open the floor to you in order to say whatever you want, to say what rubbish are you telling here. This makes no sense for me. Or even if you want to say something critical or to say something, sign concerns, whatever, right? And open to, because I said I'm working on that now, and I'm very happy to get your input. And of course, I want to try to answer your questions, but maybe I don't have the answer, right? Okay, so, well, I try. Thank you.
Well, if you allow me, first of all, let me excuse for having come a little bit late. I had a meeting before, but I attended to almost everything you've said. And let me congratulate you for the brilliant, comprehensive lecture that you have done.
Thank you.
It's a pleasure having you here in the Alpes group, in the Alpes family. Your lecture will be in the internet, and it's really great that you are cooperating with us.
I'm happy to be here.
Great, thank you very much. Hello, Dimitrios. There is the responsible, the coordinator of this activity. I would like to ask you something that is indirectly related what you have talked about, which is the European regulation on this matter. Because now we are attending a case with Twitter, and I would like, how do you do some reflections? How do you see it from the European point of view? Because we can wonder if any of these regulations can be used against Twitter if there is a transaction with an European citizen or with the European enterprise and so on. So I would like you to consider, of course, in a way that is not necessary too deep, because the situation is going on right now. Yeah. But if you could talk something about.
Well, the first issue we have to face is to discover the legal nature of Twitter regarding the different regulations we do have, right? In my opinion, of course, going from the bottom to the top, right? Because we have different labels here in the regulations and the directives that we have to take into account. First of all, of course, the first level is a provider of internet services? Yes or no? Yes, clearly. Twitter is providing an internet services, right? Secondly, is a provider of intermediary services? I think yes, right? Because you can host their things. So you are doing hosting your news, and it's a social network, right? So, or doing some, also maybe some linking too. So you can regard it as a provider of intermediary services of the information society, right? And then the DSI is going to be applicable to them, right? In a very relevant manner. As they are, can be used Twitter as a way for doing promotion, or even to be used as a search engine, right? then you may consider also the application of the regulation of P2B, right? I'm trying to protect the traders who use Twitter to do his promotion activity, right? So, and of course, we can consider that Twitter is doing one of these internet core services, and taking into account the market share that you have and the interesting new way of calculating the market share which is put in the regulation, taking into account the users number and other things like the figures of capitalization of the company and so on, which is really new, right? Then probably we also agree that Twitter is also a gatekeeper for concrete core services, right? So you are going to be able to apply all the tools that we do have in order to proceed against Twitter and try to give your best rights. Then the decision is how to proceed. Of course, you know that the DMA requires that the Commission qualifies the company as a gatekeeper, so you have to wait for that, right? But the other tools are open to be used, right? So depending on what is going to happen, probably you are going to apply the reviewed liability regime of the DSA for providers of intermediary services, right? Depends if it's harm done by a third party, or you go again Twitter if they are doing self-preferencing or are not enough transparency in applying to regulation P2B, right? So I think we can do that. We have the tools. We can think about what apply. The other issue is, are going to be effective? Do we have jurisdiction here? Probably yes, because we don't have plenty of business here in Europe. This is our luck. But anyhow, it's a very big enemy. So the fight is going to be complicated. It's complicated for the Commission. So imagine for a trader, which is probably SMEs or yes, only an entrepreneur person, natural person, right? So the issue is if the tools are going to be effective when fighting against such a giant, right? And this is one of the trends of the which is improving this regulation, the openness of the concept of consumer, or the idea that there are more subjects than consumers which are asking for additional protection in these cases, right? And so you are expanding probably the solution, which is designed for consumers to other subjects. For example, it happens in the geo-blocking regulation, right? So this is one trend we can identify probably, that the protective norms included in the European legislation are going to be much wider applicable from a subjective perspective, right? From the scope of application.
Thank you very much.
You're welcome.
I think we have a question from Melissa.
Good morning. I'm Melissa. I'm a student in Hanover. First of all, thank you very much for this class. I think that the subject is very interesting, and I got myself thinking more about it, and specifically about the problems. I wrote my bachelor thesis actually in cryptocurrencies and how to regulate it. And it's actually like it's a huge question, like how to regulate the internet. But my point would be, what's the mentality of the Commission in regulating it? Because sometimes we need to also question ourselves who are trying to regulate it, and how they understand internet and how they understand the development of digitalization. Because sometimes it's not really like we're using the wrong people to do something, but I don't know how to explain it. It's like if the Commission's really understanding it not as something that you need to limitate, even though regulation has some meaning of limiting something, creating a protection. Maybe that's a huge debate, but instead like motivating this to grow, because digitalization is indeed something that they brought us so many positive things, but using this limitation regulation to promote it, but guaranteeing that it will be also safe, and people will not, companies will still have a fair trade in this matter.
I understand your concern. I've been for 1 month ago, we have a big DAIFI Congress here in Zaragoza, right? Yes. And I was very frightened at the very end, right? Yeah. Because I might share the philosophy of the people in this markets, but if thinking from for example, a consumer protection perspective, it was terrible, right? Yes. So, and the problem is you have to take decisions. First, there is, I think, for the European Commission or for the European Union, right, as a institution, the decision of having our own jurisdiction in these issues, right? Mm-hmm. So, should we go in or not? Should we tolerate that in our territory, with our customers, happens anything what happens, and we say have nothing to say, or we have to take decisions because we have to be able to say something, right? This is and they try to do that. Right, this is MiCA, right? Is going to be very important regulation when it's passed, right? And going to affect all these issues, cryptocurrencies, DAIFI, and so on, right? Of course, and on the other hand, for example, the people of DAIFI were said, because the issue of this decentralized finances, right? They know if you are in the club, you are crazy like them, right? To say it's great because it's running and they are doing business. They're doing a lot of money, but they want to expand. They want to go to the regular consumer, right? Because there is the big money, right? And they want to go there, but they know, and investors, which are more serious investors than not risky, they are only risking 1% of their resources, but not 20% or 25%, right? Mm-hmm. But they know they need regulation. They need a regulator to be in, right? And the problem is they want to capture the regulator. This is the issue. They want to regulate, to be regulated as they want to be regulated, and this is something which not always happens, because the Commission and the European institution not always share the views and the philosophy of these people working in these emerging markets, right? So to say. So you have to balance. You have to balance between freedom, and here we have a principle which is freedom of enterprise, freedom of economic activity, right? Okay. With something, if you consider the DMA, you say, well, I don't know if the Commission is aware of that. Well, this is another issue. And you only have to protect then your citizens, your customers from some practices, right? And this is also important because if not, at the very end, all citizens are going to pay for that. That is what happened in Spain with many other issues in the financial markets, right? Okay. So you have to take measures before it's too late. Yeah. And the other problem is the decision of doing or not doing things, and the decision is how to do that. And this is very complicated, of course, yes. Because they are very quickly evolving markets. It's difficult to take concrete measures, right? It's much better to work with principles, right, and goals and aims and results, but to put that in a norm is difficult. Also because legal certainty. So you have this problem that the tools we know traditionally, the way we do legislation probably is not the best way to do legislation at the present time, right? And this, for example, DMA in this is try to be an evolution, right? Because, okay, we have this principle, but the Commission can evolve, can do inspections, can do, right? And after the result of the inspection can give new norms. Well, probably it's more operative, but we also have an issue. Is the Commission the one who was legislating in Europe?
Yeah, sorry.
Yeah.
So I think that's the biggest point, like how to regulate, how to be fair, how to find this balance. Because when I was doing my research, and we got like you have on the side, you have the company, you have those who believe in cryptocurrencies, for example, and they are totally against the regulation because they see it as a way of stopping the expansion. But my idea, maybe it's a little bit a topic, it's not like limiting this, expansion, but also making it safe. Like,
yeah, sure.
I'm totally in favor of regulating. I'm totally in favor.
You have to balance. There's a problem.
Of seeing the problem of not forgetting it, like, because I think that that's the future, that's not how we can stop it, but how we can work together. So in order it will not be dangerous to consumers, to the companies, we're not gonna have unfair trade. It will obviously happen eventually. It happens in the normal market. But I think
but the risk is too high. If you don't regulate here to some extent, you are assuming such a risk which is not worth.
Yeah.
So any rational person is going to go out of the market. Is not going to enter this market. If you think about Bitcoin, right? Bitcoin is pure speculative, right? There's no asset behind. This is crazy, right? If something happens, well, your money is poof, but already happens, right?
Partially, but it's something also that it's relatively new, and there's always this people are afraid of something that they still don't know, and then it happens with all kind of ways of exchanging money.
Sure,
so it seems to be like a scale. But but generally talking about digitalization, internet, I also worry myself, it's like if the commission who is right now working in Europe to get the regulation done, if they are really understanding like the philosophy behind of internet, how the apps, how internet, how e-commerce works, besides like the book, but really the practical view, like the life.
Well, I think they do understand, but they don't necessarily share some views, right? They understand what's going on, but they don't share all views that they are there, right? This happens in cryptocurrencies, and they do have market some. They have identified some values they want to implement, right? By ruling. And probably is something, for example, the issue of decentralized cryptocurrencies, right? Okay, and the idea of having the central banks currencies as a well, really, if you see it from an economic business point of view, the central bank currency, they don't make so much sense, in my opinion, right? Because the problem is the central banks are going to work as a commercial bank, which doesn't matter. It doesn't make any sense, right? Okay. The idea will be, okay, to substitute physical money by cryptocurrency money, right? Okay, but this is the only thing that makes sense. The issue is that the banks themselves are thinking now in having the bank cryptocurrency, right?
Yeah.
This is probably more interesting.
Yeah, I study also a little bit of that in my research, because like the point of also a cryptocurrency, and it's making it decentralized, and in the moment a bank started to produce it, it will not be decentralized anymore, and it loses its like principle of being accessible and free and everything.
Right. This is the issue. This is a view, right? But of course, the Commission is not sharing this view, or only for very specific cases, right? But they are afraid, and in my opinion, they are right, of the consequences of accepting such a view in a more general scope, right? And also, you have to think about the monetary policy, which is an issue here, right? Not only consumer protection, monetary policy, right? And economic sovereignty, right? So there are very, very, very big implications in the decisions they are taking here, right? I think it's not easy, right?
For sure, it is not. And that's also like the point. The Commission will not accept it now, but if the change in the economical sector would be so bigger that they will not have an option. Yeah. That's what happens. Like they might not have an option. They still have the power to regulate, but they need to adapt more. Depends which side of will be stronger, probably.
Yeah, this is the issue as raised at the very beginning of the Brussels effect.
Yes, right? Yes. In fact,
how far we can go with unveiling of the dance, so to say, right?
Really, very big and nice questions. Yeah, I would like to to go further in this. For sure.
Yeah, it's a very interesting issue. We have now someone which is finishing his PhD on payment systems, payment services, right? And linked to data protection and privacy, and also thinking about this cryptocurrencies and considering if it should be regulated or what should be regulated as a payment service. So this is something which is of course very relevant and is coming. And if you want to continue researching in this field, I think you have to make a good choice, a not easy choice, but a good choice. Anyhow.
For sure. So I had another question, but related to the commission. Okay. Like you need to precisely be European to be part of, to work in, or to accessorize consulting, maybe.
Can you please repeat your question, because I have not understood it?
Oh, to work in the commission. Do you need to precisely be European? Because I'm not a
Not necessarily. No. They enroll people that they are interesting for them. No, you don't have to be a European citizen, right?
Thank you.
Working for them, if you, I don't know, I'm not very keen on so to say, civil servant regulation of the European Union. Probably if you want to become a civil servant, yes, then you have to be national of a member state. But there are other positions that don't asking for nationality of a member state, right? Okay. So if you are a good and interesting person for them, they are going to enroll you. Don't worry. This is,
Thank you.
Okay.